Today I'll be talking about Section 2.8, the judicial branch of government. There are three branches of government, and they consist of the executive branch, legislative branch, and the judicial branch. The judicial branch is made up of the Supreme Court and other federal courts whose function is to rule on everything that applies to the law and the Constitution. The judicial branch of the government is the system of federal courts and judges that interprets laws made by the legislative branch and enforced by the executive branch. At the top of the judicial branch are the 9 justices of the Supreme Court, the highest court in the United States. When the judicial branch was originally formed, it was thought to be the smallest of the 3 branches of government. However, this all changed in the Judiciary Act of 1789 when the judicial branch was recognized. The Judiciary Act of 1789, which was officially titled An Act to Establish the Judicial Courts of the United States, was signed by President George Washington on September 24, 1789. The act established the structure and the jurisdiction of the federal court and created the position of Attorney General. Although amended throughout the years by Congress, the basic outline of the federal court system remains largely intact today. The Supreme Court is now considered the most important power and duty, as well as it being a key part of the system of checks and balances, which is essential to the function of the government in the United States. The judicial branch is also in charge of something called judicial review. Judicial review is the process of deciding whether a law is constitutional or not and declaring the law null if it is found to conflict with the Constitution. Judicial review was established by the Marbury v. Madison case and gave the power of judicial review to the Supreme Court and lower federal courts with respect to the Constitution. In the 1810 case, Fletcher v. Peck, the Supreme Court expanded its right of judicial review by striking down a state law as unconstitutional for the first time. Judicial review established the Supreme Court as being the best influencer in constitutionality in the United States, including federal or state laws, executive orders, and lower court rulings. The President of the United States nominates all federal judges, including Supreme Court justices, Court of Appeals judges, and District Court judges, and the Senate confirms them. Many federal judges are appointed for life, which serves to ensure their independence and immunity from political pressure. Their removal is possible only through impeachment by the House of Representatives and conviction by the Senate. Before 1869, there were only 6 Supreme Court justices, but now the official number has been set to 9. 13 appellate courts sit below the Supreme Court, and below that are 94 federal judicial districts that are organized into 12 regional circuits, each of which have its own court of appeals. Over the years, there have been many substantial and controversial Supreme Court cases. Some of these cases include Dred Scott v. Stanford, Plessy v. Ferguson, and Brown v. Board of Education. In the Dred Scott case, the court ruled that a slave was not considered a citizen and that Congress did not have the power to outlaw slavery in the United States territories. This debate would eventually lead to the Civil War. In the Plessy v. Ferguson case, the court ruled that racial segregation in public spaces was legal, establishing the separate but equal doctrine that would sanction the Jim Crow laws for a better part of a century. Lastly is the Brown v. Board of Education case. The court overturned the separate but equal doctrine by ruling that racial segregation in public schools violated the 14th Amendment.